Question 661. The conforming loan limit for California counties is A. $33,000, B. $100,000, C. $417,000, D. There are no limits on conforming loans. Correct answer is C. $417,000. The conforming loan limit for California counties in 2025 is not a single statewide figure. It varies depending on the specific county. For most counties in California, the standard conforming loan limit for a single-family home is $806,500. However, in higher-cost areas, such as Los Angeles, San Francisco, and San Diego counties, the conforming loan limits are higher, reaching $1,209,750 for a single-family home in some of these counties. Therefore, options A, B, and D are incorrect. Option C, $417,000, was a conforming loan limit from many years ago and is no longer accurate for California in 2025. The correct answer is that the conforming loan limit varies by county in California, with a general limit of $806,500 for most areas and higher limits up to $1,209,750 in high-cost areas. Since this isn't directly reflected in the multiple-choice answers, the closest understanding would be that there isn't a single limit, making D there are no limits on conforming loans partially true in the sense of a singular statewide limit, but misleading as limits do exist and are county-specific. Given the provided options, and the significant increase in conforming loan limits since $417,000, none of the provided dollar amounts accurately represent the current conforming loan limits across all California counties. Fannie Mae and Freddie Mac are restricted by law to purchasing single-family mortgages with origination balances below a specific amount, known as the conforming loan limit. Loans above this limit are known as jumbo loans. Question 662. Someone who would be judged to be incompetent may still be bound by signing a contract for A. Real property with a value below $1,000, B. Anything besides real estate, C. Real property of any value, D. Necessaries. Correct answer is D. Necessaries. Necessaries refers to essential goods and services that a person needs to survive, such as food, shelter, clothing, and medical care. The law recognizes that even someone who is incompetent has a basic right to obtain these necessities. Therefore, even if a person is judged incompetent, they might still be bound by a contract for necessities if the following conditions are met. 1. The contract was for essential goods or services. 2. The price charged was fair and reasonable. 3. The seller was unaware of the person's incompetence. In such cases, the court might reason that the contract is necessary to protect the well-being of the incompetent person. The value of the real property is not the determining factor in whether an incompetent person is bound by the contract. The key issue is their legal capacity at the time of signing. Generally, contracts for real property entered into by someone judged incompetent are voidable or void, regardless of the property's value. Therefore, the exception to the rule that an incompetent person is not bound by contracts is for contracts involving necessaries. Question 663. The ways in which the government acquires title to real estate include A. Escheat, B. Municipal acquisition, C. Eminent domain, D. Both A and C. Correct answer is D. Both A and C. Eminent domain is the power of the government, federal, state, or local, to take private property for public use, even if the owner does not want to sell. Usually, property acquired by eminent domain is used for needed government buildings, public utilities, or highways. This acquisition requires just compensation to be paid to the owner. This is another form of involuntary acquisition. While municipalities, cities, are governmental entities and can acquire real estate, the term, municipal acquisition, is broad and doesn't specify the method of acquisition. A municipality could purchase property through a voluntary transaction, receive it as a gift, or acquire it through eminent domain. Therefore, it's not a distinct legal mechanism of government title acquisition in the same way as escheat and eminent domain. Therefore, escheat and eminent domain are specific legal mechanisms by which the government acquires title to real estate. Question 664. The minimum notice period an owner must give his apartment building tenants when the building will be converted to a condominium is A. 90 days, B. 180 days, C. 6 months, D. There is no minimum notice requirement for such condo conversions. Correct answer is B. 180 days. In California, there are specific notice requirements that a property owner must follow when converting an apartment building to condominiums. According to California law, tenants are generally entitled to 180 days written notice of intention to convert prior to the termination of their tenancy due to the conversion. The owner-converter also has to provide each tenant with the opportunity to buy their apartment when the conversion is finished. Question 665. A wooden roof's highest point is called a ridge board, B. top notch, C. rafter, D. hoist. Correct answer is A. ridge board. Rafters are the sloping beams that support the structure of the roof. They run diagonally from the eaves, the lower edge, to the peak. Top notch refer to the V-shaped joint at the peak of a roof where two opposing rafters meet, but it's not the highest point itself. A hoist is a lifting device and wouldn't be part of the permanent structure of the roof. The ridge board is the horizontal board located at the highest point of the roof. It runs along the peak, where the opposing top ends of the rafters meet and are secured. Question 666. Literal rights concern properties adjoining the following: A. ocean, B. river, C. lake, D. both A and C. Correct answer is D. both A and C. Literal rights specifically concern properties that border oceans and lakes, or other large, non-flowing bodies of water like seas and bays. These rights typically relate to the use and enjoyment of the shoreline and the water. Riparian rights, in contrast, concern properties that border rivers and streams, flowing bodies of water. Therefore, literal rights apply to properties adjoining both oceans and lakes. Question 667. No two pieces of property are exactly alike, which is one of the reasons the courts devised the legal concept of A. estoppel, B. easements, C. specific performance, D. lien pendens. Correct answer is C. specific performance. Estoppel is a legal doctrine that prevents someone from asserting a claim or right that contradicts what they previously said or did, especially if another party has relied on that action to their detriment. While it's a legal concept related to property, it's not directly tied to the uniqueness of land as the primary reason for its existence. Easements are legal rights to use another person's land for a specific purpose. They address the shared use of property, not the remedy for breach of contract based on uniqueness. Lien pendens is a notice filed in the public records to warn all persons that the title to certain property is the subject of a lawsuit. It ensures that anyone acquiring an interest in the property during the lawsuit does so with notice of the pending legal action. It doesn't directly address the remedy for a breach of contract based on the property's unique nature. Specific performance is a legal remedy in contract law where a court orders a party who has breached a contract to perform their specific obligations under the contract. It is often granted in real estate transactions because each piece of land is considered unique and irreplaceable. The legal maxim, "No two pieces of property are exactly alike," underscores this uniqueness. Therefore, monetary damages might not adequately compensate a buyer if a seller breaches a real estate contract, as the buyer cannot simply find an identical substitute. Specific performance grants the plaintiff what he actually bargained for in the contract. Question 668. A voidable contract remains in force until it is A. Modified, B. Confirmed, C. Rescinded, D. Notarized. Correct answer is C. Rescinded. Modification changes the terms of the contract but doesn't necessarily invalidate the original agreement. A voidable contract can be modified, but modification doesn't automatically make it no longer voidable. Confirmed is not a standard legal term used to describe the termination of a voidable contract. It might refer to making something comply with a standard or regulation. Notarization is a process of verifying the identity of the signatories to a document. While it can add to the authenticity of a contract, it doesn't affect whether a contract is voidable or the process by which a voidable contract is terminated. A voidable contract is a valid contract that can be rejected by one of the parties for a legally sufficient reason, such as lack of capacity, duress, fraud, or misrepresentation. It remains in full force and effect until the injured party takes action to rescind, cancel or revoke it. Question 669. With a property with more than one mortgage on it, the one with the highest priority usually A. has the highest interest rate, B. has the lowest unpaid balance, C. has the highest unpaid balance, D. was recorded first. Correct answer is D. was recorded first. The interest rate on a mortgage does not determine its priority. A later mortgage can have a higher or lower interest rate than an earlier one. The outstanding balance of a mortgage does not dictate its priority. A smaller, later mortgage is still subordinate to a larger, earlier mortgage. In real estate, the priority of mortgages is typically determined by the order in which they are recorded in the public records of the county where the property is located. This principle is often referred to as first in time, first in right. First recorded mortgage is the senior lien or the first mortgage, and it has the highest priority. In a foreclosure involving multiple mortgages, the proceeds from the property sale are distributed based on recording order. The mortgage recorded first, known as the senior lien, is paid off completely before any funds are distributed to junior liens, those recorded later. Some liens, such as property tax liens, have automatic superiority over essentially all prior liens. Question 670. A seller's broker can be liable to the buyer when A. the listing agreement is of the exclusive right to sell type, B. acting beyond the scope of their employment contract, C. acting as an attorney in fact for the seller, D. either A or C. Correct answer is B. acting beyond the scope of their employment contract. The type of listing agreement, exclusive right to sell, exclusive agency, open listing, primarily defines the broker's entitlement to a commission from the seller. It doesn't inherently create or negate the broker's potential liability to a buyer for their actions. When a broker acts as an attorney in fact for the seller under a power of attorney, they are essentially acting in the seller's place. In this role, their actions are generally attributed to the seller, and liability for misrepresentations or failures to disclose would typically fall on the seller, not solely on the broker acting within that authorized capacity. A seller's broker has a primary fiduciary duty to their client, the seller. However, they also owe certain duties to third parties, including the buyer. Liability to the buyer typically arises when the broker breaches these duties. If a seller's broker makes misrepresentations or fails to disclose material facts to the buyer that are outside the authority granted to them by the seller in the listing agreement, the broker can be held liable directly to the buyer. This is because they are acting on their own accord and their actions are not solely attributed to the principal, seller.